Hello and welcome to the latest legal update for the Solicitors Group TSG Legal TV Commercial Property Channel. My name is Paul Butt and today I'll be discussing some recent developments with regard to break clauses in commercial leases. You know the kind of thing I mean, where you have a fixed term lease and either landlord or tenant or both has the right to break the lease to bring it to an end by serving notice partway through the tenancy. One of the results of the recent decline we've had in the economy is the increasing number of tenants who want to break long leases they entered into with all good faith when business was booming, but they now find that they can no longer afford to keep the premises. Lots of tenants exercising their right to break the lease, lots more case law, where landlords, of course, seek to prove that the tenants haven't quite exercised the break clause properly, not wanting to lose a good tenant when, because of the recession again, they're not able to re-let the premises. So lots of issues with regard to break clauses. I think the first thing I would perhaps mention is to take very great care on the grant of any new lease as to what the provisions are with regard to the break. It's not just enough to have negotiated the right to break after 3 years or 5 years or whatever. In what circumstances can that break be exercised? Normally, it's going to be conditional on the tenant having performed the covenants in the lease. The tenant hasn't performed the covenants, then it will lose the right to break. I'm not sure I really ever quite understood the logic behind that. What it means is if you've got a good tenant who's complied with all the covenants in the lease, you're happy to let them break, but a bad tenant who's not paying the rent, not doing the repairs, then you want them to stay on, you're going to force them to stay on by not allowing them to terminate that tenancy. I'm sure there must be some logic behind it somewhere. But it's a standard kind of provision that you'll find in a lease. But the question is, well, what kind of compliance with the lease terms are we looking for? Full compliance, the lease states that does mean full compliance. There's case law on that. Even though the particular breach causes no loss whatsoever to the landlord, there's been a breach, the tenant has lost its privilege to break that lease. What the tenant should be looking for, therefore, is material or reasonable or substantial compliance. And again, there's recent case law discussing what that precisely means. The Court of Appeal has held that substantial and material compliance mean more or less the same thing. What the court is looking for is judging the question of compliance with covenants with regard to the landlord's ability to re-let or to sell the premises. Despite the breach in question, is the landlord able to do that without undue delay, without carrying out undue work on the property? It doesn't mean that only very minor breaches will be ignored. We're talking about substantial and material. The opposite of those terms is insubstantial and immaterial, which tends to suggest only very minor breaches will be excused. But that's not the approach of the Court of Appeal, simply looking at the landlord's ability to re-let without delay or further expense. If the clause talks about reasonable compliance, that is a different test altogether. It's a question of what's reasonable in all the circumstances of the case. So try and get some protection for your tenant client on the actual drafting of that break clause. When it comes to the exercise of the break clause, I think the moral has got to be is to exercise it early and to serve the break notice in as many different ways as possible. Lots of cases where, due to people not quite understanding or following the service provisions in the lease, remember every lease has got provisions in it saying how you can serve documents on the other side. Many break clauses have special provisions just relating to them. Do check those carefully before service. And of course, if you serve the thing in 2, 3, 4 different ways, it's better to do that and get them all right and maybe be thought a bit of an idiot for serving it so many times than just serve it once and then find you haven't served it correctly because you fail to comply with the service provisions precisely enough. So do be careful on exercising the break clause. Check the names of the parties. Lots of cases where people have served a break notice and forgotten that the identity of the freeholder has changed, or that the tenant's identity has changed. This will, of course, in most cases invalidate that notice. Do be careful also that most break clauses will require the tenant to actually vacate the premises on the termination date, to give vacant possession on that term date. Do be careful in advising tenants to actually make sure that you cover yourself. You do give them firm advice that they've got to have gone on that date. If they stay on for a couple of days extra, even if they're just carrying out repairs that the landlord needs doing, unless the landlord has clearly given consent, then they will not have complied with the terms of that break clause. The lease will not have terminated, and they will have to continue paying the rent for the rest of that term, or, if they're lucky, until the next opportunity to break comes around. So I say lots of case law recently, lots of things to look out for. Serve it early. The earlier you serve it, if you realise you've got it wrong, you can serve it again. Serve in as many different ways as possible, just to make sure at least one of those is going to be served correctly. In such a case, hopefully, you'll have no issues for clients being upset because you haven't actually broken the lease in the way that they wanted you to. Well, thank you very much for listening. On behalf of myself and the Solicitors Group, thank you for listening to this legal update. Keep an eye out for further updates from TSG Legal TV, and we look forward to seeing you again soon.